Thank you so much, Barry. Thanks for that kind introduction. You tried to give me a couple of promotions, but I won't accept. And thanks to the Open Market Institute for inviting me to be with you today. I also got to just separately congratulate you and the team at Open Markets for what you guys have accomplished in such a short time after your leaving the New America Foundation. But the discussion that you guys have generated, we may agree, we may disagree on certain policies, but I think it's really important to have that vigorous debate, to have different viewpoints. It's something that I think, fortunately, our Constitution supports, protects, and provides, and our antitrust laws and enforcement is stronger and better because of it. So for that, I congratulate you and also thank you as an antitrust enforcer. I'm honored to be here among so many dedicated experts, have some friends and alum of the Antitrust Division in the room. I'm also honored that one of my favorite Senate Antitrust Subcommittee ranking member, the great Senator Amy Klobuchar, will be delivering Keynote for you later this afternoon. Events like this foster the kind of collegial civil dialogue upon which democratic governance is based. That's particularly true where people may disagree on the details of policy. Barry, I appreciate, again, what you have done and for having somebody with my viewpoints here today, even where we might disagree on certain policy issues. Almost the kindest introduction I've received in this job was from Senator Elizabeth Warren when my nomination was called to the Senate floor. In her remarks, she described me as the, quote, dream candidate to lead the Antitrust Division. Very kind words, but as I said, it was only almost the kindest introduction. Actually, her full statement was that I am a dream candidate, quote, for the giant corporations who would want to amass more power and profits for themselves, end quote. If nothing else, I suppose that shows the power of quoting out of context. So merging parties know how to do that. That was 10 months ago, and I hope the record of the Antitrust Division warrants a reassessment of that view. I'm proud of what the division has done to build on its long history of protecting American consumers through vigorous enforcement of the antitrust laws. In the last few months, we have filed charges against canned tuna executives, including a CEO, for colluding and cheating American consumers out of their grocery money. We've brought an important and in many ways potentially historic lawsuit to prevent an aspect of AT&T's anti-competitive acquisition of Time Warner from making it a gatekeeper to competition in cable television. And in another case, raising vertical concerns, we insisted on structural divestitures to cure similar competitive problems in the merger of Bayer-Monsanto. That doesn't mean the Antitrust Division is against large corporations either. It simply shows that we in this administration are unafraid to go where the facts and the law take us to protect the free markets and American consumers. Indeed, taking the vertical and horizontal components of the Bayer-Monsanto settlement together, it's the largest divestiture package ever negotiated by a U.S. antitrust agency. When I think about the, quote, dream candidate for the Antitrust Division, I put a different gloss on it than the good senator from Massachusetts did. My aspiration, and what I believe should be the aspiration of any antitrust AAG, is to be the dream candidate for the American consumer. An assistant attorney general should endeavor to use the prosecutorial powers of the Department of Justice to deliver the best results for consumers consistent with the latest economic thinking and the laws. A few years ago, that would have been a cliche. Of course, antitrust enforcers should aspire to protect American consumers. But suddenly, we find the consumer welfare standard of the antitrust laws questioned. The bipartisan consensus approach of putting consumers first in antitrust analysis is under review. It's been said, quote, it blinds us to broader goals like protecting market structures conducive to democracy. Of course, we at the Antitrust Division hear these recent calls, and it's healthy to periodically review our laws and procedures as needed. So again, I welcome the debate. We're told our investigators are too focused on consumers to do the good they could with a broader mandate. We hear that antitrust could be a panacea for a range of economic, social, and democratic ills, if only it set aside the current enforcement philosophy at its core. We also hear people saying that with a widened mandate, with setting aside the consumer welfare standard, antitrust could help win votes for the candidate or party that promises to use it. That's just the danger, of course. Antitrust has always had a political allure. Cast the blame of your ill of choice on corporate power and let the unswung hammer of antitrust be the promised solution. It's a populist cry that has slipped in and out of vogue for over a century. Today's conference focuses on online and media industries and the impact on our democratic dialogue of changes in those spaces. Of course, in America, we want institutions that make our democracy strong. That seems like a no-brainer. So as one line of thinking goes, antitrust enforcers should step beyond consumer welfare and think about what would be good or bad for our democracy, or for values like free speech, the free speech that the First Amendment protects. The suggestion is that perhaps enforcers should broaden the consumer welfare lens to think about effects on democracy or expression. I'd like to focus my remarks today on two responses to that suggestion. First, we shouldn't go down that road because enforcement actions purportedly aimed at supporting our democracy carry too great a risk of inadvertently undermining our constitutional values. Second, we don't need to go beyond the consumer welfare standard because it can get the job done on its own. Allow me to take those one at a time. The first point is that there are serious risks to democracy in abandoning the consumer welfare standard. I heard the FCC chairman a few months ago state that he and the FCC stand by the First Amendment. That's generous of Ajit. I can assure you that at the Antitrust Division and the Justice Department, we stand by the entire Bill of Rights and the whole Constitution, by the way. The values enshrined in the Constitution and the Bill of Rights are the foundation of our democracy. I was born, as many of you know, in Iran and immigrated when I was almost 10 years old with my parents to escape the persecution of religious minorities and independent thought. I know from real experience the value of a government that believes in and practices those rights we cherish in the First Amendment. It's important, and we shouldn't take it for granted. The problem with incorporating these values into antitrust enforcement decisions is the risks that doing so would be counterproductive. It's the issue Justice Brandeis explained in his famous Olmstead dissent. And I'll quote from that: "Experience should teach us to be most on our guard to protect liberty when the government's purposes are beneficent. The greatest dangers to liberty lurk in insidious encroachment by men of zeal, well-meaning but without understanding." That admonition, in fact, is inscribed on the floor of the U.S. Capitol. The message for enforcers is that the zealous pursuit of justice through prosecution, we risk prosecuting unjustly. That risk in antitrust enforcement can be significant. Enforcement decisions targeting democratic ends would invite a self-defeating exercise of prosecutorial subjectivity. Republican and Democratic prosecutors, or those of any party or political orientation, carry with them their own perceptions of what is good and bad for our democracy and for society at large. The Constitution insists they set those views aside in exercising their prosecutorial discretion, not embrace them as the rule of decision. As the Supreme Court explained in its 1963 Philadelphia National Bank decision, antitrust enforcers aren't tasked with some, quote, ultimate reckoning of social or economic debits and credits, but rather Congress has focused us on preserving our competitive economy. By giving us focus, the consumer welfare standard reduces the risk of what Brandeis called dangers to liberty from well-meaning enforcers. Nor is that a small risk or merely a theoretical proposition. For example, when we were preparing our complaint in the AT&T Time Warner case, we received a curious request from an unnamed state antitrust enforcer. They told us that they would join our case if we provided written assurances that no divestiture of that transaction would go to Fox or to Rupert Murdoch. They actually wanted to direct a divestiture based on the viewpoint of the buyer, not on what benefits competition or consumers, as defined by the consumer welfare standard. We, of course, rejected that request because it would have been unconstitutional to accede to it. The irony in that case is rich. The career staff put together a straightforward consumer welfare analysis that showed that the merger would unlawfully raise prices for cable TV subscribers and harm online innovation. That consumer welfare standard was then presented at trial, including with supporting economic analysis by a very distinguished economist. The harms of that transaction, following a consumer welfare rubric, were simply too great to accept or try to fix with some ineffective unilateral promise. The famous newscaster David Brinkley said that, quote, a successful man is one who can lay a firm foundation with the bricks others have thrown at him, end quote. Take a look at the bricks that have been thrown by some recent merging parties and think about the implications of a world where judgments about expression comprise part of that antitrust analysis. If we actually did open up antitrust analysis to considerations of what is good or bad for democracy or free speech, we would invite these attacks in case after case and lend them credibility. Without question, antitrust enforcement does not benefit from the allegations that would flow from abandoning the consumer welfare standard. Open Market's own issue papers underscore this concern. On the Institute's website is a feature titled, quote, Democracy and Monopoly, that purports to explain how more vigorous enforcement could protect and support our democracy. After a brief historical overview, which I commend, it points out that the perceived problems with under-enforcement, it says, is that, quote, Charles and David Koch provide a stark example. The essay then describes over several paragraphs, not so much the anti-consumer, anti-competitive effects of their actions, but 10 different political positions the Koch brothers have supported. It doesn't say what the conducts that the companies have engaged in or the effect on the competitive process. But it does point out that they've contributed to people, quote, teaching Ayn Rand and funding Tea Party organizations. Is that really where we want antitrust enforcement to go? To pick winners and losers based on ideology? Whether it's the Kochs or George Soros or anyone else, political positions should have no role in determining the propriety of antitrust enforcement actions. If we take antitrust down the path of considering who is funding Ayn Rand lectures, or you pick it, any other institution or foundation for that matter, we will have taken a dramatically wrong turn in my view. Elise Dorsey and her co-authors expressed a related concern in a recent paper that was published in the Antitrust Chronicle earlier this year. As they describe, the consumer welfare standard has helped to inoculate antitrust enforcement from the kind of rent-seeking and lobbying behavior all too common in government agencies. Abandoning consumer welfare and opening the door to broader arguments would, ironically, make antitrust agencies more open to the exercise of corporate influence and capture. We don't need to go down examples of how that happens. The consumer welfare standard also provides a principled basis for decision and discussion necessary to the rule of law. D.C. Circuit Judge Doug Ginsburg and Taylor Owings, a former clerk of his, who now serves as one of my counsels in our front office, recently described the necessity of due process protections in antitrust enforcement, like transparency and the right to confront evidence. These core values would be difficult to achieve in antitrust enforcement absent a consistent and definable standard such as the focus that the consumer welfare standard provides. Let me summarize the issue as Alexander Hamilton did, as a question of self-control. He said that the great difficulty in framing a government is that you must first enable the government to control the governed, and in the next place, oblige it to control itself. The consumer welfare standard, along with judicial review and congressional oversight, provides a means to control the tremendous powers granted to antitrust enforcers. All of that's to say that there could be real risks to core democratic values from abandoning the consumer welfare standard in pursuit of broader societal goals. That raises the question, is the risk worth taking? Some may think it is. I submit, however, that there's no need to accept the risks of abandoning the standard because it is more than capable of meeting the challenges that we face today. Let me next address why I think that our current standard is up to tasks to some of our challenges that we face, including technological developments that may challenge some of our thoughts about the subject we're discussing today. First of all, even when applying the consumer welfare standard, antitrust enforcement can benefit our democracy and support media markets conducive to discourse. The competitive economy that the consumer welfare standard is designed to protect supports those goals. Again, the Supreme Court's Northern Pacific case is instructive. It is often quoted for the proposition that the antitrust laws are a, quote, comprehensive charter of economic liberty that rests on the premise that competition itself yields the best allocation of our economic resources, the lowest prices, the highest quality, and the greatest material progress. Essentially, the consumer welfare standard focuses on allocative efficiencies, prices, quality, and innovation. Justice Black went on in that decision, however, to say that at the same time, and I'm quoting him, it provides an environment conducive to the preservation of our democratic, political, and social institutions. That's an important proposition. At the same time that we are enforcing the antitrust laws focused on consumer welfare, we are maintaining a free market structure that's good for our democracy more broadly. That doesn't mean, however, that we should take the risk of adding these goals directly into the underlying analysis of particular enforcement cases. Many laws serve societal goals, even where those values are not themselves liability or enforcement standards. The tort system, for example, has the important benefit of civil dispute resolution. It keeps people with conflicts from fighting it out, or as Alexander Hamilton did, dueling with pistols. Yet no rule of tort law adjudication considers relevant the likelihood of particular litigants resorting to violence. That value is a byproduct of the legal regime, but not a case-specific element for consideration. To frame it in economic terms, the consumer welfare standard that focuses liability determinations on harms to competition and consumers creates positive externalities for American democracy. That's how antitrust supports our core values, without risking them by incorporating them directly into decisional rules. John Sallet, a Deputy Assistant Attorney General in the prior administration and a friend, has a forthcoming article on a similar consideration as it appears in the legislative history and in Brandeis's views of antitrust enforcement. As Sallet explains, while, quote, the purposes of antitrust law can be broad, the mechanism of antitrust is legal. As prosecutors, our job is to apply enforceable legal standards that identify harmful industrial conduct in a manner that vindicates social and democratic values. Consumer welfare for us is that standard. It's also important to emphasize that the current standard is capable of addressing the enforcement challenges presented by emerging digital technologies. Those advocating abandoning consumer welfare have often attacked a straw man. They describe the standard as requiring a myopic focus singularly on downstream consumer prices to the exclusion of non-price values and the competitive process. This narrow approach, in turn, can be attacked for inability to confront technological changes that are redefining our democracy. Recent enforcement experience, however, I submit, belies that notion. The D.C. Circuit described the breadth of the consumer welfare standard last year in affirming the United States' victory, challenging the merger of health insurers Anthem and Cigna. Quote, product variety, quality, innovation, and efficient market allocation, all increased through competition, are protected forms of consumer welfare. Likewise, the antitrust laws protect competition even in markets that are not end consumer facing, such as the labor markets alleged in our recent and ongoing actions against employer no-poach agreements. The current standard also recognizes that consumer harm can arise from conduct that distorts the competitive process. For example, in the division's complaint challenging information sharing agreements between DirecTV, AT&T, and other potential distributors of the Dodgers channel, this harm was called out explicitly. The complaint alleged that the agreements, quote, deprived the Dodgers fans of a competitive process. Innovation effects have been an ongoing but relatively recent focus of the Antitrust Division. I explained a few weeks ago in Rome how innovation is central to consumer welfare. The divestitures obtained in Bayer Monsanto just 2 weeks ago demonstrate this focus. In response to the division's concerns that the transaction would impact R&D in seeds and crop protection products valuable to farmers across America, the division obtained significant divestitures, as I noted earlier. Several aspects of the divestitures specifically target preventing a loss in innovation from the transaction. All of this was done through the application of the consumer welfare standard. Likewise, the standard is capable of innovation itself. As markets and technologies and economic understanding evolve, so does its application. As I've spoken about recently, revealed consumer preferences can help us ascribe consumer values to zero-cost goods like those provided by some internet platforms. As we consider consumer welfare in new kinds of markets, the standard allows for its application to new markets, just as it did in the Microsoft case in the 1990s. I'll conclude with a quote from a great president, perhaps not of you, shared by everybody in this room, Ronald Reagan. The 9 most terrifying words in the English language, he often said, are, quote, I'm from the government and I'm here to help. The Gipper had perhaps a more plain-spoken way of echoing Justice Brandeis's caution about the dangers to liberty in the well-meaning encroachment of government. As you consider the health of our democracy and the role of media platforms and other institutions in it, I urge you to recall the surest path to undermining the First Amendment, exercising government power based on viewpoint. The consumer welfare standard does not blind us as enforcers. It focuses our decisions on appropriate considerations like price, output, innovation, quality, and choice. Enforcement of the free markets for the benefit of consumers can be achieved with great success and greater fidelity to the rule of law within the contours of that standard than without. Thank you again for allowing me to join you today.